right? So the violation of human rights, um, like your right to bodily integrity, for example, and what we're going to be talking about today, your right to life. Arrest, although it may be the most, uh, what's the word, the most secure, as in a guarantee, it might not be the most appropriate. And we come back to the balancing of rights and the question in terms of Section 36, is there a less restrictive way or means to achieve the same purpose? Now, coming off of that last series of lectures, we also said that, yes, arrest exists. It is a way, but it is the most drastic way, particularly given which rights and freedoms can be violated or will be violated through arrest and arrest procedure. Now, with arrests, if I had to ask you, what does it mean if someone's been arrested? Could you describe arrest and arrest to me? So if anyone wants to just unmute their mics and explain to me what happens or what you understand happens in an arrest from a layman's perspective, what you may have seen on TV, what you may have read in the paper, what you may yourself have experienced.
Yes, I think in most cases you are taken against your will, and they would force you to sometimes do things that under normal circumstances you would not have done, but because of, yeah.
And how would they arrest you? If you were telling the story, or if you were
Right.
listening to someone's story of how they got arrested, what sort of words, language, descriptors would they use to explain what has happened?
Like they came to my house, maybe they banged the door. In some cases, you'd find that they will step over the fence. No one has opened the gate, but you'd find them inside, and they will force you to lie down. They will point guns at you. They will do sort of all sort of things. Sometimes they even beat you.
Right. So that's what we're getting to. We're building up to that point that a layman's understanding and pretty much everything that we see on television and the news gives descriptors of arrest procedure as being violent, as being forceful. Okay. That force is used, and to some extent, we would say excessive force has been used. Beyond excessive force, deadly force. Now, it becomes a problem when excessive force is used, but it's an even bigger problem when deadly force is used. Why are we saying it's a bigger problem? Because we've got to ask, well, what is the purpose of an arrest? What goal does an arrest seek to achieve? And it's the same goal as with summonses, as with written notices, as with warnings. What is the purpose of an arrest?
I think it's to apprehend the suspects or get the person in custody of the police or to courts.
That's the point, to bring them to court. But you can only bring someone to court if they are alive. And it's only an alive person, suspect, that can answer charges laid against them. And even through all of this arrest procedure, even the charge, etc., you are still just a suspect. Even when the trial begins and you are accused number one or accused number two, you're not guilty yet. Is that correct? So,
Yeah.
an arrest that involves deadly force completely and absolutely cuts out any possibility, logically and biologically, of this suspect having their day in court, right? So it's very, very important for us to bear that in mind. But having said that, at the same time, The use of force in arrests may well be necessary given the circumstances. And having gone through the audio and the slides and the notes, you'd have been able to work out by now under what circumstances use of force, use of excessive force in a sense, would be necessary. And the hot topic that we're going to be talking about today is the use of deadly force. What does the Constitution say regarding use of force generally in relation to Section 49 of the Criminal Procedure Act? And more specifically, what does the Constitution have to say and what have reported judgments said about the use of force in effecting arrests? So yes, the courts are concerned by the overzealous use of force, right? And we can see this through, and we say videos, although I haven't posted any videos for you, these are videos that you would have seen gone viral, clips that have been appearing on the news, on your various social media threads regarding use of force, use of deadly force. All right, so there are a number of concerns, human rights concerns particularly, that come into question when we consider arrest procedure, and the use of deadly force. So there's a couple of cases that are important for our discussion. Govender is one, Walters is another, Basson is another. And you got to look at these cases in a transgression for the evolution of what South African law currently is regarding use of force and use of deadly force when effecting arrests. And these cases, you would have noticed that they don't only deal with use of force and use of deadly force by police officers. They also refer to use of force by private citizens in effecting an arrest. Okay, and that's what you're going to see also in Walters, what you're going to see in Govender, and here in Martinez as well, where the court gives a caution. Because when we were discussing arrests at the last lecture, generally, we saw that regular citizens like you and I are empowered in terms of the Criminal Procedure Act and the common law to effect what we would call citizens' arrests, right? And in conjunction with that, we are also allowed lawfully, as much as police officers are, we are allowed lawfully to use force to effect an arrest, which translates also to the use of deadly force. But that being said, the use of deadly force and excessive force does come under scrutiny. And we've seen, having worked through Govender, through the slides and the audio, which you would have, Basson, Martinez, Walters, etc., what the effect is. In other words, what must be satisfied to say that, no, this was not murder, it was the attempt to conduct a lawful arrest. So you must look at what those factors are. In other words, what we're saying, what are the factors to determine that in this case, although the force used was deadly, it is not in itself a criminal offense, it was in a sense justified. So we're going to skip then ahead, because the best way to understand this is to deal with the tutorial questions that you were given. And there were 2 tutorial questions, which I hope you've worked through. And the first one, Section 49 of the Criminal Procedure Act deals with the use of force. Section 49 of the Criminal Procedure Act deals with the use of force in effecting an arrest. Critically discuss the constitutionality of the use of deadly force with reference to any relevant cases, particularly the case of ex parte Minister of Safety and Security in Read the State versus Walters. Now, how would you deal with that question? How did you deal with that question? What kind of a question is this? Anyone?
Essay.
It's an essay question. And how would you deal with this essay question? So the rules pretty much are the same. Whether you're dealing with a problem question or you're dealing with an essay question, you would still best be suited logically to ensure that you're actually dealing with what you need to be dealing with. If you break it down, if your starting point is Iraq, right? So what is the issue here? And why is it important that we identify the issue properly?
For me, the issue would be the use of force, and maybe what constitutes the use of force. Under what circumstances are you allowed, and under what circumstances are you not allowed to use force?
Okay, so
I think
that's sort of it. But you need to also include that it's the constitutionality. Now, why am I being so particular about this? Because if we left this out, right, if we left out this thing about constitutionality, unless you're able to properly and absolutely focus, you run the risk of not dealing with the constitutional arguments, right? So, like we said, identifying the issue properly ensures that you deal with what you ought to actually be dealing with in what is meant to be the bulk of your answer, right? So, and I'm not saying that what you said was wrong, because we've not had sight of your full answer, but from a planning perspective, and for you to be able to come back and say, well, have I answered the question? You need to have these markers. And so throughout your answer, or at the end of it, basically, you know, well, have I dealt with constitutional aspects, right? Does that make sense?
yes, it makes sense.
Excellent. Okay, so now moving on then. Moving on to rule of law. Now, rule of law will always be the biggest part of any of your submissions. Why? What does rule of law require you to do?
Doesn't rule of law test whether or not you know which law is applicable to the question?
So it is the law, right? It is your discussion of the law on what? On the constitutionality of the use of deadly force in effecting an arrest. So you need to be talking about the law as it relates to deadly force in an arrest situation from a constitutional perspective. Now, having picked up on that, it means that you've got to give definitions, right, of these things. And when we talk about the constitutionality, so not only definitions, right, but also particular case law. So the law is made up of statutes, cases, and journal articles, right, for our purposes. Because these are going to be your reference points. So you'll have to talk about statutes, and you'll be talking about the Criminal Procedure Act in Section 49, what it was and what it is. And that will be your discussion of the case law. So here you'll be talking about Walters, you're talking about Besson, you'll be talking about Govender, right? And the developments that happened resulting in the various amendments to Section 49. And the reason why there were various amendments was because of this question of constitutionality. Okay? Does that make sense? So you can see that the rule of law will be the biggest part of your discussion. Now, in an exam question or a tutorial question like this, how would you deal with application? There's no set of facts necessarily for you to deal with. What is your application here? Here, your application becomes an analysis, right? Giving commentary, a critical analysis or critical commentary on use of force, use of deadly force in effecting arrests, having laid out the law as it stands, generally, right, in relation to all of this. What does it mean? So not just a summary, but an understanding. What does it mean? And that's where, and then your conclusion would be, well, in South Africa, use of force is constitutional, use of deadly force maybe, okay, depending on how we would deal with it in the cases. Does that make logical sense to you? I hope. Any other views on how you would have approached that from a stylistic perspective? Is everyone happy with that? Okay, so we can look at the next question then. On the night of the 2nd of October 2019, Constable Big was cruising the streets of Pietermaritzburg in a police car. He was doing a routine patrol duty. A few minutes after 11 o'clock, he received a radio message that there had been a bank robbery at National Bank in Church Street. According to this message, a security guard had been killed in the robbery. He was also told that the robbers had made their escape in a blue Toyota Corolla motor vehicle. Upon receiving this information, he proceeded with speed to the place of the robbery. When he was about 2 blocks away, he noticed a blue car fitting the description of the robber's car, driving in the opposite direction. He did a U-turn and followed the car. After a dangerous high-speed chase, the blue car collided with a lamppost, and the occupants jumped out and ran off into the night. Constable Big followed one of them. He called to the suspect to stop. He fired a warning shot in the air and shouted to the suspect that he should stop or be shot. In spite of this, the suspect kept running. It appeared that the suspect could run faster than Constable Big because the gap between them was widening. Fearing that the suspect would escape altogether, Constable Big shouted, "Police, stop or I'll shoot." In spite of this, the suspect kept running. Constable Big then pointed his 9mm pistol in the direction of the suspect and fired a shot at him. The suspect fell down immediately, and by the time Constable Big got to him, he was already dead. Constable Big was charged with murder of the suspect. How would you deal with this question?
Yeah, I think the same, obviously, with the IRAC that we were doing before.
Excellent.
Identify the issue, which is, oh, where's my screen? About the use of deadly force, whether he should have tried to stop the person running away by shooting at him and killing him, whether that was justifiable.
Yes, was it justifiable? That's the point.
Yeah.
What does justifiable mean you have to deal with?
What do you mean?
What does justifiable mean? What does the word justify or justifiable trigger for lawyers, trigger for criminal lawyers, trigger for defense attorneys?
Was it reasonable?
Reasonable? Right. So in an ordinary context, justifiable means, is there a justification? Is there a good reason that would take away the unlawfulness from the unlawfulness, therefore making Constable Big not guilty of murder, right? So in a general sense, it means, well, is there a good reason? Is there a defense? Was his actions reasonable? And we talk about reasonable because in this context, because in terms of Section 49, in terms of everything that we spoke about at the last lecture, we used reasonable, reasonably suspects, reasonably believes, etc., right? But also we're talking about the reasonable man, the reasonable police officer in those circumstances. Would they have done the same, right? So this thing about justifiable it's important to note. Justifiable also means one other thing in this context. In this context, justifiable also mean constitutional, right? Building on from the first question that we looked at. So these are the trigger points that you need to be thinking about when you get to the rule of law part of this question, that there are several things that I need to consider when I'm discussing rule of law. So what does Section 49 say? Right? What does it say? What case law supports that? What articles inform how we understand and deal with what is the law regarding deadly force, and when is it justifiable? When is it reasonable? When is it defensible? Right? You're seeing how these trigger words are working now. Oh, something else I wanted to say. Justifiable, reasonable, defensible. Right? Case law. What case law do I have at my disposal? The big one, Govender, Walters, which led to the development of what we have as far as Section 49 is concerned now. But the one that ought to have caught your attention is that of Basson. Why should Basson have grabbed your attention? Because in this scenario, factually, the facts of Besson were very, very similar to the facts that you were given in this problem scenario, right? Now, this is where we're taking your working and your understanding and your application to a higher level. So Besson was 1961, pre-constitutional, and certainly before Govender and certainly before Walters, which was in the late 90s and 2000s. So although the facts of Besson are similar pretty much to the facts that you were given in this scenario, the judgment or the logic applied in Besson may not be a copy and paste for this scenario, given what? Given our current constitutional dispensation. Right? So you'd have to look at Besson. You'd have to look at the Besson judgment and see what the court reasoned, how and why. You'd be looking at that ratio. You'd be looking at how the court interpreted reasonable, etc. pre-constitution. Then you'd have to look at Govender, Walters, and the new Section 49, and various journal articles and academic articles written on the point. And if the way in which reasonable and justifiable is the same, even pre-constitution as was discussed in Besson, then we can apply what happened in Besson. Otherwise, we may have to go a different route. Does that make sense? And that's where your application would come in. You'll say, although Besson, the facts of Constable Biggs' matter and Besson's case are exactly the same, we can or cannot simply apply the rule of law as expounded in Besson. And we can do it, for example, here's an option, because the principles are the same, although it happened before the Constitution, are same considerations of what are reasonable. Alternatively, depending on how you reason, they are not the same, and therefore we have to give, this decision may well be outdated, unconstitutional, and for that reason we have to follow a different route, and that will be your application and conclusions. Does that make sense?
Yes, yes, we're following you, ma'am.
Okay, excellent. So that's pretty much all I have to say about that. Now, you know, if you've worked on an answer, we can happily discuss it, like the merits. Otherwise, you've now got a plan of action of how to deal with this question, right? I have put up readings for you from you know, various academics who've written on this question of use of force, use of deadly force, the constitutionality, and those are the articles and the arguments that ought to be informing your understanding and your argument on these types of questions, particularly here. So yeah, go ahead, Bonga Koke.
Yes, I just wanted to check regarding such questions.
Mm.
Would it be wrong to just go back, like we were saying, we're talking about definitions, to first talk about force, like how we did at specific offenses, or is that just a long way around? You just go straight to the issue at hand.
At this stage, if the dispute was whether or not force was used, right, then you'd be discussing it. You'd have to discuss that. Yeah.
Okay. No,
But it all depends on the context. And you'd know the context if you successfully identify the proper issue.
The issue. Okay.
Now, if you've got days and days and no page limit and no time limit, then you certainly can deal with every comma and whatever. But in a timed situation, and even in court, the court will expect you to not deal with the stuff that is not in dispute, right? So for example,
Okay.
Constable Big is being charged with murder. Murder is defined as what is the definition of murder?
You're just putting me on the spot, right? Unlawful killing of a person.
Unlawful, intentional causing of the death of
Intentional.
another human being, right? So you won't be spending 3 days arguing before the court that the thing that was killed was a human being, right?
Mm.
No. But you may have to spend time discussing intention,
Yes, yes.
right? Because did Constable Big have intention to kill? Maybe it's not murder, maybe it's
Okay.
culpable homicide. I don't know, right?
Okay. Now it makes sense.
Okay.
For
You want?
me,
Yes, go ahead.
based on
Rebecca.
based on section 49, because UB says that flees when it is clear that an attempt to arrest him is being made and they resist such attempts and flees. And from the facts that we are given, the person did flee, and he also did shout to him to say, "Stop! It's the police." And he also shot warning shots. So I think a reasonable person, that's a reasonable thing to do.
It might be, but let's
So
go back to this. Let's go back to this. And you must go back to read Walters, read Govender, all the excerpts and the quotes taken. I think it was paragraph 108 or something from the judgments. What if when fleeing, because this is important, when fleeing, is the suspect, when fleeing, posing a danger? That's an important thing, right? Because when they are fleeing, are they dangerous? Are they waving a gun around, or are they just running away? You
but
have
then
to
he
look
will
at
catch them.
you have to look at what those requirements are. You have to look at what those requirements are, because just because Constable Big can't run fast enough won't be a good enough reason to shoot a suspect.
Okay.
All right, so there's a number of factors, the nature of the offense the person is suspected of having committed, and is there enough? Is there enough on those facts for Constable Big to reasonably believe that this is the suspect from that robbery? It's very factual. It is something that will be on a case-by-case basis, but we have general guidelines. And the biggest one is when fleeing, at the time of fleeing or trying to evade arrest, is the suspect at that point being a danger to the life of the police officer or those around him or her? That would be a big use of deadly force was not legitimate, to the way I understand it.
Okay, but now I'm just trying to think. So I'm not trying to justify him killing the person.
Mhm.
I'm just trying to think of a case because police have a job to do.
That's the thing. We cannot, at the same time, and this is the quote, you cannot tie the hands of the police. Isn't that the quote that we always hear?
Mm.
Yeah. So it's a fine line. It's a philosophical as much as a constitutional human rights argument on both sides that we are trying to traverse. And you've said it, Rebecca, you've said it. Police have a job to do. We expect them to keep us safe. But at the same time, we don't expect them to just shoot at people. Certainly not just kill people, because remember, at this point, it's just a suspect.
Mm.
And nothing in our set of facts says that Constable Big witnessed this person get into that blue car and drive away, and that's when he pursued that blue car.
Mm.
So it could have been any blue car. There are too many variables. So go back. You must go back to the previous set of slides, listen to the audio, look at how do we work out what is reasonable suspicion. Forget use of force. Now we're just talking about reasonable suspicion to effect an arrest. That's our starting point. Then the question of force comes in as a secondary. Yep.
Yeah.
It's not easy. It's not supposed to be. Any other questions? Okay, well, I think if we've got no more questions, then that's a wrap from my side. Yeah, and then I will see you all next week.
Thank you.
Okay, thanks everyone. Have a great week ahead.
Mhm.